I practice labor and employment here in Texas, both in the federal sector and in the private sector, and representing primarily employees regarding their employment-related issues. Today, we will be discussing severance pay and severance agreements and non-compete agreements, and what restrictions apply to non-compete agreements, and how to negotiate a severance and a non-compete agreement. And we can move on to the slide regarding severance pay. So severance pay. What is severance pay? Severance pay is defined under Texas law, specifically the Texas Unemployment Compensation Act, as a dismissal or separation income paid on termination of employment in addition to the employee's usual earnings from the employer at the time of termination. In other words, this means severance pay is monetary compensation paid to an employee upon their separation. Texas employers are not required to offer severance pay. There's not a Texas law that requires Texas employers to offer severance pay. However, if the employer promises severance in a policy, a company policy, or in the employment contract with the employee, then it must be paid. Severance pay is typically calculated based on the length of employment of the employee. For example, an employer may calculate severance pay based on how long the employee has worked for the employer. If the employee has worked for the employer for 1 year, the pay may be calculated based on that versus an employee that has worked for the employer for 10 years. Severance pay is an agreement between an employer and employee. Again, just to emphasize, the employer is not required to offer severance pay. However, it's offered as a matter of an agreement with an employee that is separating from employment. Next, we'll talk about severance agreements on the next slide. So a severance agreement is a written agreement or contract in which the employer agrees to make severance payments. It's a signed contract between the employer and the employee, and there's typically terms in severance agreements that are included. Some of the terms you see listed on the slide include agreements not to sue, confidentiality clauses, non-disparagement clauses, non-compete clauses, non-solicitation clauses, and a clause regarding the deadline to sign. This is not an exhaustive list, but these are typical clauses I've seen in agreements where I've negotiated on behalf of clients I have. With regards to the agreements not to sue, this means that the employer is conditioning the payment of severance to the employee if the employees agree not to sue the employer based on any specific allegations that the employee may have. Typically, the employees agreeing to waive their rights to bring claims against the employer to agree to severance. The next clause is confidentiality. This typically means that the employee is bound by confidentiality, meaning they cannot disclose the terms of the severance, the terms of the agreement, what led to the agreement. And we'll note here that the NLRB has recently issued a decision on confidentiality clauses in these types of agreements and restricted the types of confidentiality that may be included in the severance agreements. Specifically, the NLRB has said that employees may still bring certain types of claims regarding illegal activity or retaliation, and still disclose those items to the NLRB or another entity. Next, the non-disparagement clause. This means that the employer is requesting that the employee agree not to disparage or negatively comment on the employer's business in the public sphere. The employer is requesting that the employee agree to this term in exchange for severance. Non-compete and non-solicitation clauses, which we'll talk more about. But the non-compete clauses are clauses that prohibit the employee from working in a specific industry that the employer has a business in, or a specific location within a specific time period. Non-solicitation clauses are clauses that prevent the employee from soliciting the employer's clients, customers, vendors, or even their employees to the separated employee's new business. A deadline to sign. This means that most agreements have a deadline for the employee to sign the agreement or else forfeit any severance that's given. For example, when a severance agreement is issued from the employer to the employer may say, you have 10 days to sign. If you don't sign by 10 days, then we're withdrawing the severance offer. As will be noted later, there are certain exceptions to this regarding older workers and their deadlines that they must have to sign an agreement. To the next slide regarding non-compete agreements. Non-compete agreements, as we mentioned earlier, are agreements by an employee not to compete with his or her employer for a specified period of time in a specified location or in a specified method. For example, an employer may request that an employee not engage or work for a business competitor within a year in a specific state or locations where the business operates, and the employer operates. So it prevents the employer from working in the same line of business as the employer. It prevents the employer from disclosing trade secrets. Employers often couple their non-compete clauses with non-solicitation clauses, as we mentioned earlier, which typically prevent the employer from soliciting either employees to another employer or the employer's customers, clients, or vendors. These type of provisions may prevent you, for example, from selling to your current customers, even if you brought them to your employer. So, for example, if you were working for a company and you were able to generate a client for that company, but you separate from that company and go to a new company, a non-solicitation clause may prevent you from bringing that client over to your new company. Texas law generally does disfavor these restrictions on employees' mobility or non-solicitation. However, there is law to support employers having these clauses to protect their business interests with non-compete agreements. On the next slide, we're going to talk more about the restrictions on non-compete agreements. So regarding the restrictions on non-compete agreements, first, it's important to know that non-compete agreements are governed by the Covenant Not to Compete Act in Texas. Under this act, the non-compete agreement must be part of an enforceable agreement. This means that they're not separate agreements, they're a part of other agreements the employee may sign that are enforceable, such as severance agreements. Texas law says that the non-compete agreement must be reasonable as to time, geography, and activity being restricted. For example, it's not going to be reasonable to prevent separating an employee from working in a competing business for an unlimited amount of time. Or, for example, it's not going to be reasonable for the employer to prevent the employee from working anywhere in the world. There must be reasonable limitations from when the employee is able to work in a competing business. And another example, as far as activity being restricted, it has to be specific activity. The employer cannot prevent an employee from working anywhere. Even if it's in a competing business, the employer should be specific enough to say what their competing business is. For example, if the employer states that you can't work anywhere in sales, well, that may not be reasonable. The employer should be more specific as far as what type of sales that the employee cannot work in for that period of time. Courts will consider the type and size of the business, the type of consideration offered to the employee to determine whether these restrictions are reasonable. And another note here, non-compete agreements are typically not enforceable to states where the employer does not do business. So, for example, if you move to a different state outside of Texas and the employer doesn't have a business operating there, those states, or at least Texas, typically won't enforce those non-compete agreements upon those other states because the employer does not do business in those states. And we are done with that slide. So negotiating severance and non-compete agreements. So as far as negotiating severance and non-compete agreements, we have several considerations here when you're negotiating these. So first, you want to ensure you're receiving the appropriate pay and benefits. You should review these employers' policies on the standard amount of severance pay. Some employers will state in their policies how much severance they will offer to an employee. You should also review the employer's policy on the amount of accrued paid time off that you may be paid. For instance, the employer may state in their policy that they do not pay unused but accrued paid time off. Another consideration is you have to see if you have any stock options. If you do, determine whether you could exercise those stock options. Determine if the reason that you're being separated from the employer is unfair or whether you're going to challenge that reason. There could be several reasons the employer has decided to separate you from employment. It could be a layoff. It could be specific to you regarding your performance or conduct. If you dispute those reasons, it's important to notify your employer and to even perhaps contact an attorney to challenge those reasons. If you're challenging those reasons, you have to consider whether or not you do want to sign the agreement. Because if you sign the agreement, as we stated earlier, there's typically a clause where you're waiving your rights to further challenges regarding any employment issues. Therefore, if you believe that the reason that you're being separated is unfair, you should notify your employer, and you could use that as a tool to help negotiate even a higher severance. For example, you could challenge to say your separation is discriminatory, and you plan on filing a claim with, for example, the EEOC or the Department of Labor or the NLRB, but you'll agree not to file a claim if the employer agrees to pay you a higher amount of severance. And in my experience, that has worked to get a higher amount, but it's not guaranteed because the employer may have their own opinion. Another consideration here is, if the employer includes a non-disparagement or confidentiality clause, ask that it be mutual. If the employer is asking you not to disparage the company, ask that the employer also not disparage you. Now, the employer may want you to specify what specific employees that you do not want to disparage you, but this could be important for you if you're looking for a new job and you don't want the employer to say anything negative about your work to your future employer. And that goes hand in hand with the confidentiality clause, as far as keeping confidential what led to the separation or the terms of the agreement. You would want the employer to also make this confidential as well. As we've been discussing, as far as non-compete and non-solicitation clauses, you have to determine whether they're reasonable or not. We've talked about the unreasonable clauses as far as time and place. If those are preventing you from getting work, you need to challenge those clauses. As we mentioned, Texas law disfavors these unreasonable restrictions. I will also note the federal government has also proposed a rule regarding these restrictions, and it's proposed that employers do not include non-compete clauses in these types of agreements. That rule is still proposed, it's not finalized. However, it does show that across the board for not only federal employers, but private employers are becoming more restrictive on these types of non-competes. So you should make sure you review these clauses and ensure that they don't prevent you from working in your line of work. And again, you should ask for a reference, as part of from your employer as part of the agreement. This could be a neutral reference, just making sure the employer gives you a reference to a future employer, maybe merely stating that you worked there and that you had acceptable performance, or this is what you were paid. You just want to protect against the employer from making any kind of negative remarks about your employment. You could even perhaps ask for a positive reference or even a letter be written that could be helpful too. As far as negotiating severance and non-compete agreements, here are some main tips for negotiating these types of agreements. First, you should ensure that you're receiving appropriate pay and benefits if you're offered severance. Review the employer's policies for any standard amount of severance paid. Review the employer's policies on payment of unused accrued paid time off. Typically, employers will have policies regarding what, if any, paid time off that the employees accrued will be paid. But you want to make sure that the agreement that you've been given includes the language that's in line with the policy of the employer. Another note is if you have stock options with your company, determine whether you can exercise the stock options even after employment. Another tip is to determine whether the reason why you're being separated from your employer. If you don't agree with the separation, if you believe it's unfair, you should notify your employer or consider making a challenge to the reason. And this could be a method to negotiate with the employer either a higher amount of severance or additional clauses within the agreement. If you believe, for example, that your severance or your separation is due to some kind of differential treatment, such as discrimination or retaliation, you should make that known to your employer, or you should consult with an attorney who could advise you of your rights of filing a type of claim. And if you make that known, or if you make these challenges to your employer, the employer may come back and may accept your claim or may want to negotiate a higher severance. And of course, they could decline your claim as well and only offer the severance noted, but you should at least, be aware of your rights. And if you disagree with the reason for the separation, make that known, make that challenge either through yourself or through an attorney. The employer, like I said earlier, will usually include a non-disparagement or confidentiality clause. You should always ask to have that mutual. A non-disparagement clause means that you can't disparage the employer, but you should ask that the employer doesn't disparage you. Typically, employers will want you to will want specific names of people you may believe disparage you, because if you work for a larger company, it may be difficult for the employer to control all of its employees as far as not disparaging you. But if you are in fear that a specific supervisor or a specific colleague may be disparaging you to a future employer that you're applying to, you may want to ask in the agreement specifically that this person cannot say anything disparaging, or this is what this person could say. As far as confidentiality, you should ask that the employer keep things confidential as well. I do note that we received a question on this, before the presentation regarding the NLRB, the National Labor Relations Board's recent ruling on confidentiality clauses and the restrictions now on employers. And those restrictions are preventing employers from including broad clauses that prevent employees from making claims of retaliation or going to the NLRB. Employers are still allowed to include those clauses, but they can't prevent employees from making, specific claims to the NLRB regarding unfair labor practices or telling the NLRB about retaliation that has been going on. And that was a recent ruling by the NLRB on confidentiality clauses. Another tip as far as negotiating the severance and non-compete agreements is to determine whether the non-compete or non-solicitation clauses in the agreements are too broad or unreasonable, and that they prevent you from working in your line of business, or if the clauses are unreasonable on time and place. If so, challenge the clause. As described earlier, if there's an unlimited time that you're permitted to, or you're prevented from working in the employer's line of business, that could be cause to challenge the clause and ask for that clause to either be removed or place restrictions. As mentioned earlier, Texas does allow employers to include these clauses, but they still have to serve the business interest and they still have to be restricted. So if you believe the clause is unreasonable on its face, you should ask that clause be revised. I will also note that the federal government has proposed a rule regarding eliminating non-compete clauses within agreements. It's still in the proposal phase, to my understanding, and it still needs to be finalized, but that would be applied to even private sector businesses. So it may be the case in the near future that employers are not permitted to include non-compete or non-solicitation clauses, or at least to have those clauses severely restricted. The last tip on this slide, at least, is for negotiating these types of agreements, or is to ask a reference be provided by your employer as part of an agreement. As you know, employers are being separated from employment. Despite the severance, employers are probably going to be looking for new jobs or new employments elsewhere, and you would likely probably want some sort of reference from your previous employer. Well, you could ask that be included in the agreement, that the employer give you a specific reference. Most employers, in my experience, will at least agree to a neutral reference for most employees, where the employee's job titles, length of work, last performance is provided. However, some employers may even agree to some sort of even more positive reference, that the employee performed exceptional during their time here. But it doesn't hurt to ask that a reference be included, so long as you want it. Of course, there may be situations where a reference may not be needed or desired from your employer, but it may be helpful, especially in a separation that's somewhat disagreeable between the employer and the employee. It may be helpful to ask for a reference to ensure that the employer does not make any negative remarks to a future employer that you may be applying to. Some additional considerations on the next slide. Older workers provisions. So in agreements, there may contain provisions regarding the Age Discrimination Act or the Older Workers Act, which applies to employees that over the age of 40. They're given additional protections when reviewing these agreements. Specifically, employees over the age of 40 are permitted to rescind their acceptance on an agreement, meaning if they sign, they're permitted to rescind their acceptance within 7 days of signing. In addition, employees that are qualified are allowed to consider the agreement for up to 21 days. So this means that some employers will give 7 days or so, or for example, to some employees to sign an agreement. However, for employees over the age of 40 that qualify under these provisions, they're permitted a longer period of time. Unemployment compensation. Typically, employees being separated from employment may seek unemployment. To be qualified for unemployment, you normally need to have been separated without a good cause, and it was typically a release. But if you resigned as well, you may not be qualified for unemployment. So you want to ensure your separation is not characterized as a resignation. Otherwise, the Texas Workforce Commission may not grant your unemployment. Of course, facts do differ, but typically you do not want your separation characterized as a resignation. I do note here that you should still be eligible for unemployment if the payment that you've received is considered severance. You should still be able to apply for unemployment compensation. Another piece of advice, consideration, is that most employers will conclude in the agreements that what law applies. And for Texas employers, it should be Texas law. However, there are companies that operate in Texas but are headquartered in other states, for example, California, New York. And so there may be a clause in there that says, well, California law applies. Be aware of that. In certain cases, that could even be challenged, especially if the main job duties that you performed were in Texas and your records were kept in Texas. However, most employers will include a provision as far as what law applies if there were any challenges to the agreement. Most employers will also include mandatory arbitration provisions. This means that if you challenge the agreement, that the employer and you will agree to adjudicate your challenges through arbitration and not in court. These clauses you need to be aware of because they could be binding. There are certain exceptions regarding mandatory arbitration, but if you need to be aware of those because you need to be aware of what you're signing. The challenges could be that you were not aware, or that it wasn't clear to you that what you were signing, or there are certain claims that may fall out of the mandatory arbitration provisions. However, again, these clauses could be binding, so you need to be aware of that, when you're reviewing and signing an agreement. So I will, let's see, jump to any questions. And I'm going to look back to see if for any questions that we received before the presentation that I could help answer. We received questions regarding COBRA benefits, and COBRA benefits are a continuation of benefits that employees can receive after separating from employment, and whether those benefits could be monetized. Not necessarily. I mean, that's, again, it's going to fall back to the employer's policies, but employers will include, a COBRA benefit clause to employees that employees could take advantage of for a specific amount of time. Another question we received during the chat was, what if an employer doesn't have any separation policy, including in the employee handbook? Well, if the employer doesn't have a separation policy, it's not required to offer a severance agreement. However, if you signed a contract when you were hired on with the company, there may be a clause in there regarding any severance to be paid out. If there's nothing in there, then it's not required. Employer's not required to offer a severance. However, if they do, then that contract is the contract that will need to be discussed and negotiated with the employer. Received several questions, regarding before the presentation, just regarding looks like bringing wrongful termination claims, harassment, what to do in those situations. As I discussed earlier, if you disagree with the reasons for separation, if it was the employer downsizing, or if the employer decided to separate you specifically, those are issues that you could bring up if you don't believe those are correct to the employer. I would advise to hire an attorney to discuss, those issues, to determine what claims you may have. And in those situations, employers may be willing to negotiate with you on a higher severance amount. Again, the facts do differ. The employer may deny that. However, that is something to discuss with an attorney to determine whether you should file a claim. So another question, we received is an employer is sent an employment agreement. If they don't sign, they can no longer work for them, and there was no negotiation. Well, this is somewhat similar to what I was discussing. If you don't agree with the agreement that's been sent to you, then you shouldn't sign it, and you should consult with an attorney regarding any claims you have. If you don't want to consult with an attorney or don't have the means to, you should at least point out some of the clauses that are probably in that agreement that I mentioned here today to discuss, certain challenges you may have. Just because the employer hasn't negotiated with you doesn't mean you can't go back to them. If they're refusing to respond, then if you don't want to sign it, then I wouldn't advise to sign it. I would advise to talk with an attorney to determine what claims you have. If you don't sign the agreement, That means that doesn't mean that you can't bring a claim. You could still consider filing a claim regarding, your separation, especially if you don't sign that agreement. So another question, a similar question was, how much can an employee push on severance pay when fired for no reason, but the contract was stacked against the employee? Well, if the severance agreement was signed and there was a clause in the agreement that says you cannot sue, then that's going to be a roadblock for you actually suing. If you've signed an agreement waiving your rights, then that's going to be difficult for you to sue after that. But if you didn't sign the agreement and you're asking, or if the agreement's still pending, to push on that, you could either bring claims regarding any discrimination, retaliation, harassment, illegal activity going on in the workplace that you observed. You could go and try to argue that you should receive higher pay because of your length of employment or your performance at the workplace, especially if the employer doesn't have a policy in place regarding that. You could argue, well, you worked, at the workplace for a number of years, and therefore you should receive a higher severance. This isn't a rule or law, but what I've seen in my practice is typically employers will pay out severance, again, for how long the employee has worked there. And I've seen some employers base it on giving certain months to number of years. For example, if you worked, for the employer for 6 years, then the employer will give you 6 months of severance. Again, that's not a hard and fast rule, but that is a typical guideline that you may see that employers utilize. And then I'm just looking over any other questions that we may have. A lot of the questions seem to deal with, specific challenges an employee may have regarding prohibited personal practices, age discrimination, which, again, if you believe you need to make those claims, you should raise those to the employer. And if the employer is denying those claims, you have certain rights to go to the EEOC, to make those claims of discrimination. Another question I see here that we received before the presentation is, under what circumstances would an employer offer severance to somebody employed less than 90 days? Well, the employer may pay an employee that's been employed for less than 90 days if it's per their policy, or if there was a contract involved. If there was a contract that the employee signed that says they have to be employed for at least 90 days to receive any severance, then that's going to prevent any kind of severance. But again, the employer is not required to offer severance. If you're trying to seek severance, even though you've worked there for less than 90 days, it doesn't hurt to ask and raise any claims that we've mentioned here today, regarding any harassment, discrimination that's occurred. And you can make those claims again to the EEOC, the Texas Workforce Commission, which do investigate claims of discrimination. That's the Equal Employment Opportunity Commission and the Texas Workforce Commission, that do investigate claims of discrimination or retaliation. But that's where you would make those claims if the employer is not offering you severance, even though you've been working there for 90 days or less. We just received a question on the chat. If you're in New York, well, this does apply to Texas. If you're in New York, you'd have to consult a New York attorney. I believe states have similar processes as far as where to file and what types of claims to file, but you have to consult a New York attorney on specific what types of claims would apply there. And I'll just hold for a minute to see if there's any other questions in the chat. So this question involves bringing class action suits against an employer if there were a large number of employees that were fired. So class action suits are suits of individuals, more than one individual, of course, bringing action against a specific employer, a specific entity. Class action suits have certain requirements. There's a numerosity requirement. There's a commonality requirement. What that means is that the claims have to be common, have to be similar enough, and there has to be a number of people bringing the claims. Just 1, 2, 3, 4, 5 people isn't going to qualify for a class action, at least in my experience. Typically, class actions are hundreds of people. Again, so numerous the class actions regulations are, numerosity. That doesn't mean that people can bring the same claims against the employer and not use evidence or talk with one another. However, those would have to be separate claims if it's less than, typically around, if it's only about 1 to 10 people. But again, facts do differ. Obviously, it would depend on the number of people. But the federal laws that deal with class actions require that class actions be big enough, and that, in my experience, is usually hundreds of people. Well, another question, is, as far as just, retaining an attorney, that is your choice to retain an attorney. Our contact information is here on the slide. I do just, want to emphasize that, this presentation doesn't, supplement or doesn't stand in place of any specific legal advice, that an attorney may give you. This was an overall guidance on this process, but we have included our contact information here, as far as seeking specific legal advice on your certain circumstances. We're not seeing anything else in the chat, so I think we are going to conclude here. Again, I do want to apologize for the tech issues and the late start, but I do appreciate you still tuning in to this webinar here today. Thank you very much.